Welcome, everyone. Thank you for joining us at the end of the day in Asia for this webinar on environmental on EIA compliance and enforcement by environmental and climate law and governance expert Matthew Baird, who is part of our ADB technical assistance that is hosting this webinar. This is part of ADB's Law and Policy Reform Program under the Office of the General Counsel. This TA aims to improve the teaching and application of environmental and climate laws, including strengthening and building networks in the region around environmental law and knowledge sharing, such as what we're doing today. Thank you so much. We have a great audience tonight. This is the second of this is part 2 of our webinar on EIAs, and we're going to have a lot more, so please stay tuned. There is a Google form. If you would like a certificate, may I request everyone to turn off their mics if they're not speaking? There is a Google form in the chat box that you can fill up so that you can receive a certificate of attendance in a few days. And now I will turn over to Ms. Patty Moore, our moderator. Let me introduce her quickly. Patty is an environmental lawyer with 30 years international experience working in the field of environmental law and governance across more than 30 countries in Africa, Asia, Europe, and Latin America. She has been living and working in Asia since 1999. Since 2010, she has been working with ADB on the legal foundations for environmental safeguards, which include the basis for environmental impact assessments. And that's why we are so lucky to have her be moderating our discussion after Matthew's presentation. And she's currently supporting work on ADB's Safeguard Policy Update. Patty?
Okay, thank you very much, Christina, and good afternoon or good evening, everyone. It's my privilege today to introduce Matthew Baird. As Christina just mentioned, Matthew is currently the Regional Environmental and Climate Law and Governance Expert for ADB's Office of the General Counsel Technical Assistance Project that's sponsoring this webinar. Matthew is also, among other things, the Director of the Asian Research Institute for Environmental Law. He's a visiting scholar at Vermont Law School. He's a teaching fellow at the College of Law in Australia, and he's a fellow of the Environment Institute of Australia and New Zealand. Matthew has over 32 years experience in environmental and planning law in Australia. From 2008 to 2012, he was chair of the Environment and Planning Law Group of the Law Council of Australia, which is Australia's peak body representing the legal profession. Matthew's a member of Law Asia's Committee on Environmental Law and IUCN's World Commission on Environmental Law. He's worked widely in Southeast Asia on environmental law and particularly on environmental impact assessment. Especially, Matthew has worked with ADB, with UNDP, UNEP, and also with the International Finance Corporation on a range of EIA-related matters, including integrating climate change into EIA and strategic environmental assessment processes, and has provided draft technical reviews on over 100 EIA and IE reports. His doctoral dissertation at the University of Southern Queensland is on EIA in ASEAN. Matthew, over to you. We're looking forward to hearing from you today.
Thank you, Patty, very much for the kind introduction, and welcome to everyone. So good morning. I know we've got some people coming from Europe, and good afternoon. We've got people from India and Sri Lanka, and also a lot of people sort of closer to Southeast Asia as well. So thank you all very much for joining us today. And as Patty said, I mean, I have to say it's extraordinary an honour also to be introduced by Patty because of her. She has done an enormous amount of work on environmental and social safeguards in this region. And for those of you who missed her talk on biodiversity law within ASEAN, that is also on our the ADB eLearn website. And there's probably a link in the teachenvironmental.law.asia, and I recommend you to look at that if you've got an interest in biodiversity law and practice. So today we're going to look at, it's sort of like a part 2 from the first presentation, which was looking at comparative assessments for EIA in Southeast Asia, mostly focused on ASEAN. And today I want to broaden it out a bit to look at sort of compliance and enforcement. And so I will give a talk for about 30 minutes, and then we'll have lots of opportunities for questions and comments, because I think in this particular topic, there is a real lot of expertise in the audience that we have here today. And so sharing that experience is probably very crucial for effective compliance and enforcement. And last year on the 24th of June, 2021, I think it was, it might have been 2020, the IAIA had a workshop on compliance and enforcement and brought together a number of speakers. And that was followed up with a discussion paper on compliance and enforcement, the IAIA, the International Association of Impact Assessment. And I'd like to acknowledge the enormous work done by Cheryl Wasserman, formerly of the US Environment Protection Agency, on issues of environmental impact and compliance and enforcement in particular. So I'm going to start sharing my screen and go through the presentation. And as Patty has said, if you can post questions in the chat box, that would be great. And there will also be an opportunity later for further questions and discussion. So Patty, let me know if that's working.
Yes,
at the moment, thank you very much. So the issues in compliance and enforcement of environmental impact assessment are obviously very, very complex. But I thought I'd start very quickly in a quick overview of what EIA is, and partly because I think it's still an exciting examination to think, what is environmental impact assessment? So very broadly, we can talk about EIA as the process of identifying, predicting, evaluating, and mitigating a number of environmental and social impacts prior to decisions being taken and commitments made. And I think this is still one of those key definitions of EIA, is it's about the prior assessment. So before decisions are taken and commitments are made, the assessment has to occur. But it's also, as it says, about mitigating. So not only is it about predicting and evaluating, but the mitigation of those impacts is inherent to the idea of EIA. There is also clear objectives. They're still subject to some discussion. There's a lot of comment and perhaps some criticism as to whether EIA is in fact something that should be done for environmental protection, or it is something that should be considered as part of the sustainable development process. But certainly one of the things that EIA does is it's about gathering information. It's also about obviously public participation, and it's about distributing that information and assessing those potential impacts and mitigating those before any decisions are taken for the project to commence. But I also wanted to say from a legal perspective that we're also seeing a development of the idea that environmental impact assessment is a customary norm of international environmental law. And this was a long discussion paper that Professor Tsai-Ming Yang, where he reviewed 197 jurisdictions, or 197 jurisdictions with 183 of them having specific requirements for environmental impact assessment. In our region in Southeast Asia and South Asia, only Singapore is an outlier for having no formal system under law for environmental impact assessment. They do have procedures under their pollution control processes, but nothing that is formally or could be formally recognised at that international level as environmental impact assessment. Certainly what had happened earlier is that working on basic principles of international environmental law and the obligations of states not to cause harm to other states from activities within their own states, this principle of not causing transboundary harm. There are a number of court cases that the International Court of Justice heard where they looked at the responsibility of states to undertake transboundary environmental impact assessment. And these court cases at the International Court of Justice reaffirmed the need for transboundary environmental impact assessment to be undertaken before the activity occurred that could cause the particular harm to that adjoining state. Interestingly, in those cases, the court did not go into any detail of what might actually be a component of either transboundary EIA or in fact a national environmental impact assessment. The court did say that some of the things that needed to happen within the process of a transboundary EIA is that the adjoining party needed to be notified and needed to have the opportunity to comment on the activity or project before it actually was given the go-ahead. But the court didn't go into the detail of precisely what constitutes an EIA. Professor Yang did look at some of the components of an EIA and some of the principles, but this may still be the subject of further discussion. For me, I always believe that EIA has certain fundamental requirements, including access to information and public participation. It should have an opportunity for people to comment on the EIA process. It should, of course, have accurate and valid scientific data, and it should be a fairly legitimate, clear, determined process that enables people to understand that decisions are made on the basis of clear scientific evidence rather than on the basis of evidence that they're unaware of or haven't been advised of. Now, within the context of EIA, as it was developed from the 1970s, we've now seen a number of different components or elements to environmental assessment. The first is strategic environmental assessment, which is looked at in the basis of looking at plans and policies. It can be more than project-specific EIA. In addition, cumulative impact assessment has emerged where a consideration of the multiple or the impact of multiple projects or different projects. And then they've got EIA, which is often based on a particular project. And then in this chart, which is adapted from an IFC document, it then looks about, once you've approved the EIA, we have environmental monitoring leading to environmental audits as certain tools that are part of this environmental impact assessment process. But of course, what that has now meant is that while we see the sort of standard steps in the EIA system, screening, the scoping, the investigation by an EIA consultant, including public consultation, and the reporting, the preparation of an EIA report for review by the government or the relevant authority, followed by a decision taken by the relevant authority, followed by monitoring. But now we see very clearly that has emerged from the consideration of EIA that monitoring is clearly part of the EIA process. It no longer stops just at the decision when a project is given approval and an environmental compliance certificate or approval documents are issued. Monitoring is now very much seen as an integral part of that EIA assessment process. The other component of environmental impact assessment that has emerged significantly is the idea of risk assessment. The idea that certain issues within environmental impact assessment have to be subject to a risk assessment, whereby the EIA will address the major, the moderate, the significant risks that might emerge, and others that are less significant or have less or manageable impact may not be addressed in the same sort of manner or in the same sort of detail. So we're now moving to the idea that the risk assessment process is becoming a very core component of an EIA, whereby particular issues that might be of specific risks, such as waste or such as pollution or such as chemicals, resettlement, are all biodiversity risk, climate risk, are all given a certain priority because they are seen as risks that have either particular major severities or a likelihood of consequences is high. And so this creates this risk assessment where you have extreme risks, which should of course be removed by project redesign or rejection of a proposal. And then you have high and moderate risks That should then be the focus of your environmental management plan or some alternatives to the project, whereas low risks can sometimes be merely managed within an environmental management plan with little focus on those by the EIA consultant. But then the question is, well, let's look at how this compliance and enforcement, how it matters within the EIA process. Now, within compliance and enforcement, we have a certain standard approach. On the one hand, we have self-regulation, which is a recognition, I think, that the complexity of environmental impact assessment, the complexity of major projects, and the lack of resources for many line ministries is that we're relying significantly on the self-regulation, on the project proponent to do self-monitoring, self-reporting, and their own regulatory follow-up. And the follow-up occurs when that self-monitoring or self-reporting identifies a particular error or a breach. At that level, then we move to a certain degree of compliance, and that could be administrative orders to require some waste to be fixed or some process to be fixed to avoid pollution or to avoid an impact. If that keeps going, or if there's some harm, there might be a penalty notice, a simple notice that requires the company or the operator of a facility to pay a fine. Finally, there might be some administrative suspension of a particular activity. For example, trucks that might be on a construction site might be suspended during a certain period of time because of the impact that they have. And then that is elevated to an enforcement process where you can have civil actions for damages, remediation, criminal actions for sanctions, and loss of permission where the project proponent might lose the permission to actually continue with the project. And these were the subject of the discussion within the IAIA meeting, and these three key messages. One was that compliance enforcement touches on the EIA process its entirety. The other is the breadth of the issues are a significant challenge. And finally, that compliance, enforcement, and follow-through are perhaps the biggest impediment to achieving positive results for the EIA process. We all know of the problems within the EIA process. The question is, how can we fix it? It's something that is now seen universally as a process that is adopted by almost all states in our region. So how can we fix up the compliance? So I want to look at some three areas. One is prior to the EIA process. And this is, of course, the most significant and difficult. The first is to have legislative requirements that requires governments to provide clarity in the application of strategic environmental assessment or EIA, when is it done, in which circumstances, things like pollution control laws. Most of these things are already in place in the region, but some of these need to be updated. The use of strategic environmental assessments is probably even more important in a compliance and enforcement way, because many people will say that over 70% of your impacts, your environmental and social impacts of a project, are locked in once you've chosen the particular location. Location of projects, whether they're roads, ports, industrial zones, tourist facilities and the like, the location of those are often going to significantly impact on what are the environmental and social impacts. And so that means the use of strategic environmental assessments for large-scale infrastructure planning, trying to locate where the best location for a port, for example, might be, given issues of climate change, coastal erosion, impacts of coastal processes, but then also how the roads and the rails and the other infrastructure from that port are going to link in with your cities, your urban areas and the like. Strategic environmental, special economic zones often being used in this region. And of course, it would be appropriate to use a strategic environmental assessment to locate those areas where you want these strategic environmental, the special economic zones, to be located. Strategic environmental assessments can also identify what projects or what type of projects you might want to propose. For example, in energy, if you choose, if a government is choosing to source its energy from coal or gas, that will create a significant impact in terms of greenhouse gas emissions, which will have to be factored into the environmental impact assessment. The other important thing is the need to ensure that there are clear requirements for early risk assessment for key issues. Climate change, biodiversity, social impacts, Indigenous people and resettlement are all key risks that could be identified very early on in the process, even before perhaps the project goes into feasibility. That early risk assessment, and indeed the Asian Development Bank adopts a strategy called AWARE, which is a particular type of program that provides for a significant amount of climate risk assessment and biodiversity risk assessment within the early stages of planning particular major projects. The other thing about statutory compliance is that there should be clear penalties for non-compliance. Too often, the non-compliance is left up to the ministry or the courts without clear penalties for non-compliance, including fines, restoration orders, publication orders, and suspension of project approvals. And there should, of course, be clear legislative protection for public participation in the EIA process and the compliance process. It has to be an enabling environment for people to be able to participate within the EIA process. So within the EIA process itself, now that we've moved into the idea of a particular project starting to undertake the EIA process, there are perhaps some issues that were raised. And these were some of the discussion that came out of this IAIA workshop. The idea of registration of consultants. Too often people have considered that EIA consultants require a lot more training, a lot more professional development. I have been a member of the Environment Institute of Australia and New Zealand now for over 30 years, and that was one of the early EIA professional associations that adopted professional ethics, and it had an ethical board that reviewed complaints against EIA consultants. This was a voluntary organisation, but it was also an organisation that was committed to ensuring EIA consultants had the skills and the necessary ability to be well-trained, but professional and act in a professional way. That is one of the things that many people comment about in terms of EIA processes. There can also be things within the EIA assessment process to require the adoption of best available technology. The idea that best available technology, which might cost more, but of course it will have the benefit of reducing environmental impact. If companies don't wish or are unable to adopt best available technology, then there is perhaps the necessity to justify why that's not going to cause environmental and social impact. There can also be a focus within the EIA process on harm avoidance and minimization. We've already talked about a principle of EIA is to mitigate the potential impacts, but that focus can actually be enhanced. For example, when a project is to consider alternatives, if there is resettlement required, perhaps the project should be required to consider a no resettlement option or a minimum resettlement option. What would happen, or what would happen to the project if it had to look at a no resettlement or minimal resettlement option? That might require significant redesign. But we do now know that resettlement and livelihood costs are very significant, and often they don't succeed or they don't achieve the objectives in the long term. And that has huge human rights and social impacts. The other thing we can do within the process is to look at, for these major projects, the requirement that they have to comply with particular international standards, such as environmental management standards, the ISO 14001. And that, of course, the EMS system then, of course, has a whole process of regular accreditation and regular auditing of that environmental management system. So that, again, is a sort of a reinforcement. The need for the environmental management plan for all EIA projects is essentially one of the mandatory requirements within EIA across sort of all jurisdictions. But that EIEMP can also be made more powerful by ensuring that there is a consultation with local communities. Some other things that can be identified within the EIA process is establishing community consultation and making sure that community consultation with impacted communities can be continuous from the very beginning of the EIA process and something that can continue through operation. And very importantly, the idea of establishing grievance redress mechanisms so that people can, if they have concerns, raise them in a formal way with someone within the organisation and the company or the project who can take action. So that's within the EIA. These are some of the issues that have emerged in discussion on how you can enhance compliance within the EIA process. And then looking at the idea of when a project is approved, and often and I use the phrase environmental compliance certificate to mean an approval documentation. And so this was also a particular focus because that approval documentation is something that is looked at both by the EIA professionals and the engineers who have to implement the project, but it's also looked at by the lawyers who work out whether or not a project is in compliance with its obligations and how they're managed. And so the important thing about the environmental compliance certificate is that there should be an environmental approval document that covers these conditions and clearly can identify the legal obligations that a project proponent, the consultants, the engineers, and the operators need to follow. So those conditions and obligations need to be clear and well drafted. And some of these could be standard conditions. The idea that we could develop standard conditions maybe for sector or with a particular country so that people are aware that certain conditions are standard across all projects, and then you can have sector-specific conditions. The other thing that the conditions need to cover is both the construction, the operation of the project, but they can also cover the closure and decommissioning of the project. So those conditions can be cover the complete sort of life cycle of the project, and they may also require certain plans, environmental management plans, to be developed in detail at each step of the process. And that then ensures that this environmental compliance certificate should also require, as a legal and clear condition, compliance with the environmental management plan. An environmental management plan, we know, can be and should be updated at different stages of the project. A construction environmental management plan will be different from an operational environmental management plan, but the operations may change over time, in which case the environmental management plan may need to change. But it should always be a requirement that the project proponent or the operator has to comply with the environmental management plan. The conditions can and should include a continual community consultation and operational grievance mechanisms. And these are things that should continue for the life of the project to enable the issues that concern and impact on communities and local communities can be addressed. And one of the other things that the environment compliance certificates can do is they can look at requirements for insurance and bonds and funds for remediation. And this was one of the perhaps more innovative responses, that within the environmental compliance certificate, it may be required that a project proponent has to have insurance in the event of an accident, or a performance bond in the event of some incident or some accident that the government can access to ensure that they can use that money to clean up, to immediately respond to an environmental or social incident. The other thing is the funds for remediation. Again, mining companies often use this as a standard requirement that they have to put into a fund for remediation and restoration at the conclusion of a project. These can be also applied during the lifetime of any project to ensure that there is an ongoing period or ongoing fund that is available in the event of environmental harm. At the end of the project or at a certain point, that bond or those monies can then be released as the project is closed or finished off. But it certainly ensures that there is funds available in the event of an accident or a challenge that the government or the line ministry can readily access. The environmental management plans are also becoming more important in environmental impact assessment and project management. But the environmental management plan still has to relate to the EIA report. And I think any of us who have worked in this area have seen environmental management plans that don't pick up on those risk areas that have been identified in the EIA and focus on those areas of significant risk. we might see a lot of conditions relating to recycling and rubbish, but less focusing on hazardous waste, water pollution, air pollution, and the like. There should be some public participation in finalising the EMP. Communities should be engaged to understand what is going to be required in terms of a management program, what the company and operator will be doing. EMP contents and checklists, I think, can be very, very clear. Again, should be based on that risk assessment and analysis, which is why risk assessment is becoming very important in EIA, especially as projects are becoming much larger, much more complex, and with much greater impact. The environmental management plan also has to identify actions, responsibilities, and timeframes, and very, very clearly it needs to identify who is responsible for what and when is it meant to happen. And given that opportunity, it also ensures that there can be opportunities for communities to be able to observe these reports and see how they're managed. Budgets need to be operationally funded. I've seen some EMPs that say they will be funded out of the corporate social responsibility plan. The view must always be, if your environmental management plan cannot be funded through the operations of the project, it means the project cannot achieve its environmental objectives. Again, the environmental management plans themselves may refer to the ISO 14001 and other standards for occupational health and safety and the rest. And above all, there needs to be clarity in reporting. And I, again, believe very strongly that these should be public. It's very important, I think, to demonstrate clearly if a company is relying on self-regulation and self-reporting, there's an obligation to make that reporting public and to make that reporting clear. And finally, the post-approval EMP process has to be there to ensure that there is a possibility of revising the environmental management plan in the event of problems or issues or unanticipated consequences. These are things that are very important to ensure that that environmental management plan becomes a living document. And then in terms of moving on to once the EIA has been approved and the environmental management plan has been adopted and the project is operating, then how should we have some of these sort of monitoring obligations? And this is where perhaps we can use a range of techniques. Monitoring and reporting should be public. This is something that a number of people often worry about because they're concerned that the community might become officious bystanders, or that people who object to a project can then maintain their objections as long as the project lasts. But I think the important thing about EIA is to recognise that once an approval is issued, it's a legal document. So the important thing about the legal document, especially the environmental compliance conditions and the environmental management plan, is that they should be reported to the public. The public are part of the stakeholders in the EIA process, and they have an obligation and a right to know what is occurring and how it's going to be managed. They can certainly then see if there are errors or mistakes or things that need to be improved, and that's the advantage of having certain grievance redress mechanisms or community consultation committee, that these can be then reverted back to the operators before the need for escalation. The other thing is technology that can be used and required as a condition of approval. Technology has advanced enormously. It is certain technology is costly, but part of that cost is because it's designed to reduce adverse environmental and social impacts. Water monitoring, air pollution monitoring can all be identified on a regular basis. These days, air pollution monitoring can be done on a 24-hour, 7-day-a-week basis, and it can be live streamed to the net and people can watch. Cameras can be used to demonstrate that pollution control equipment is on, and that sort of level of technology can also be used. It does cost, but again, it's a cost that has to be considered in the consequence of ensuring that these conditions are complied with. And again, we are going to self-monitoring by companies. Many people suggest that that should change, but the cost imposed on regulatory authorities is probably too great. So therefore, we do give companies and project proponents a lot of opportunities with self-monitoring. But that means with all those obligations, there has to be mandatory notification requirements for breaches. And in a number of countries, including Australia, there are higher penalties for failure to notify. If you don't notify a breach, the penalties are often a lot higher than if you actually notified your breach. Often, of course, if many of these breaches have to be using good technology, good reporting, they'll also be identified. So it will all come out eventually. The other thing that's been looked at a lot is industry-wide audits and public rating of results. And that's something that Indonesia has used in industrial sectors and looked at particular operators within that. And some have been given better results, some have been given worse results, and that is made public. Environmental audits are also very, very key, so that the regulating authority can also require a particular company if they're concerned about an impact or because the community has expressed that there is some environmental or social impact. So they can be required to have an environmental audit, and that is an independent auditor with the power to make recommendations with publicly available information and the results of the audits. Again, these can be quite challenging to companies, but it's part of this idea of the development of a social license, that if they have the obligation to be responsible for self-monitoring, they also have to accept that environmental audits and reports will be public, and if there are breaches, those breaches will also be made public. The other thing about independent audits, and again, this is one of the things that has emerged, is that there are some can be more successful than others. In India, the independent auditors, the environmental auditors initially were paid by the companies, and so the companies contracted someone to audit the company, and compliances were not always identified. And then one state shifted to an idea where the company paid the regulating authority a particular amount of money, and the regulating authority, the government regulating authority, commissioned the independent auditor themselves. So the report was then presented to the government. Non-compliance reporting jumped up to about 80%. So the auditor, who was contracted by the government, even if the money was ultimately from the company, saw themselves as being much more focused on identifying breaches and reporting that to the regulatory authority, who can then take further action. The other thing about monitoring, again, and I come back to this idea of community consultation committees, it's something that has emerged given the complexities of projects, is that the community consultation committee can be this regular forum to discuss issues from the development and from the implementation of the environmental compliance certificate and the management plan. It can include representation from the project affected people and key stakeholders, because there may be some value in having engineering or environmental professionals sitting on a committee so that they can help interpret some of the data. It's often run by the project operator, but it can also be funded by the project operator and run by the community, again, depending on the capacity of the local community and the size of the project. And these are some of the things that mining operations often look at, because they have a very strong connection, especially through noise attenuation, dust attenuation, and traffic and transport. They can have significant community impacts. Things like hotels and other operations, unless they're very large, may not have the same need for a large community consultation committee, but they can still engage with the community on a regular basis. And again, grievance redress mechanisms for the project and also worker grievance redress mechanisms are seen as invaluable ways of ensuring that the environmental management plan is complied with. And finally, issues of other enforcement options in terms of economic incentives. It's very common in mining uses for remediation funds to cover mine closure and restoration. That goes into often a statutory fund that is managed independently of government. It's designed to ensure that those funds are not used by government or not disbursed without the appropriate regulatory approval. But there are also opportunities for insurance requirements for activities and damages, and requiring then the insurance market to then develop appropriate bonds and other financial instruments and insurance to cover those environmental and social impacts. And many projects are able to do that, but it's not always a requirement that in the event of the project creating some harm, that there will be an opportunity for those impacted to seek damages from that company. Performance bonds in case of specific breaches could be for $1,000 or $1 million, depending on the impact that might be caused. But again, it enables governments to be able to know that they can act and spend money in the cleaning up and the dealing with an environmental incident, and there will be some bond or some financial guarantee that they can call upon, so the government will not be out of pocket. And above all, in terms of enforcement, the cleanup and containment should occur first before the arguments about liability and the costs of restoration. The final thing I wanted to talk about was then what happens if you are planning to take more enforcement action, going to courts and to take civil or criminal penalties. There are a range of enforcement opportunities that are in existence for environmental impact assessment and other environmental offences. The idea of administrative orders, where the particular ministry can impose an order for cleanup or for action to be taken, and it's a mandatory order. There are issues where you could create environmental mediation approaches, or an environmental court to deal with resolving environmental disputes or prosecuting civil and criminal violations of environmental laws, or the environmental impact assessment approval document, which is often a legal decision, and therefore can be a breach of that can be actually a breach of an offence. But I also think the important thing here is the idea of an independent environmental protection agency with a mandate to enforce conditions for EIA and pollution permits. It's very important that this independent agency, even if it's within the line ministry, is given the opportunity to identify which projects they want to enforce conditions and which pollution issues they need to exercise their enforcement duty to either enforce an order or a cleanup order or a restoration order, or create penalties. And then the final thing is the idea of an establishment of a process for restoration and compensation for environmental harm. If all the previous things have failed, and we now are facing environmental and social impact, there needs to be a process for restoration and compensation for environmental harm. And that probably has to be beyond just environmental impact assessment, but it has to be for all projects, activities that cause pollution or environmental or social harm, and within a broader system for compensation and remediation. And so in conclusion, the EIA process does not stop at project approval. We now recognise it goes beyond, and it can be enhanced through the professional conduct of EIA consultants. Environmental approvals and conditions of approval should be public. Breaches and environmental interests should be notified to the government and community. There is the opportunity to use economic instruments that need to be considered and looked at in terms of insurance, performance bonds, and then the community engagement in transparency are very important considerations now. That people have to also be able to freely participate in the compliance process and protected from reprisals or attack, including legal actions. So people who are taking actions against polluters or those who breach the EIA conditions should be protected from defamation cases or cases against trespass, to ensure that the environmental impact is offences are brought before the court. And finally, a strong and independent enforcement agency should be able to bring enforcement actions, hopefully as a last resort, to issue orders to prevent ongoing environmental harm and require compliance with the EIA approval conditions. I realise that that's been a very broad look at some of the issues about obligations for EIA compliance and enforcement, but it shows the breadth that we have to look at, not just during the EIA process, but before, and not just after the EIA approval has been issued. There are many steps that we can avoid environmental and social impacts and ensure that the community and the environment is protected while there is an opportunity for sustainable development. Thank you, Patty.
Thank you, Matthew. And thank you very much for, for highlighting something that's coming out as ADB and other multilateral funders have already done this, the World Bank, the Inter-American Development Bank, and others, looking at strengthening the links between the EIA process and particularly community participation and stakeholder participation, not only at the level of project design, but all the way through a project, which ADB already requires, and then also into the monitoring and particularly the compliance. And that is something I think there's going to be a lot more discussion on as time goes by. We do have a couple of questions that have been put up here, but to just start off something, I wanted to ask the participants, and there are like more than 100 of you, 125. If please raise your hands if you have particular examples of what you consider to be good practice, particularly with EIA compliance, but it could be any aspect of EIA in either in your work experience or in the country where you live. We'd like to hear from you, and then I'm sure Matthew will come in with a couple of other examples from his own experience and his own research. Let's see, is there anybody? No hands? Okay, IAIA, would you please unmute yourself and give us your example?
Hi, Matthew.
Hi.
Long time no see. Yeah. Hi, everyone.
Minglava.
Yeah, Minglava. So let me introduce myself first. My name is Itiha. You can call me A. I'm from Myanmar. So Matthew explained about this compliance thing. Yeah. So everybody knows about the EDB, World Bank, IFC, and also the JICA. There are a lot of the development agency working in Myanmar. And also in the meantime, private sector also invest in Myanmar. But that is a 6 months ago. So one after the submission of the report, the project proposal, especially they only the one they got the the loan from the the development agency, they will follow the the EMP, and they will submit the require the follow-up document like a monitoring report or whatever. But for the other the private sector, they rarely submit this kind of the follow-up report to the to the Environmental Conservation Department, which is a regulatory the agency in Myanmar. So this is the situation in Myanmar. So but Matthew explained about the this about the the EIA consultant role, and also about this project proponent. I think also it's also the regulatory body. They need to also have some the involvement in the sending out the notification letter. So this is you are already due for the submitting the monitoring report or whatever. This is a requirement. Another one is this is another one is what I found out is in the the garment industry as in the Myanmar. So they are also following the the buyer requirements. So a lot of the garment industry, they got the consignment, especially CMP, cut manufacture and packaging. So they need to follow the their buyer requirement, and in that case they are following the EMP, and they are also monitoring their environment and their impact. So this is a situation. So I think also Matthew, you also need to talk about what should the regulatory agency need to be involved in this kind of the strengthening the regulation. Yeah, thank you very much.
Matthew,
would
you like to respond? Or do you want to take the other questions first?
Yep, happy
Okay,
to take the other questions.
Okay, sure. Okay, Rory, I think your hand was the next one raised. Would you please ask your question or give us your example?
Yes, this is not a question, but an example. I am Rory Kagimbal, an environmental EIA specialist from the Philippines. Here in the Philippines, my example would be on the process of preparation of the EIA, particularly in the environmental management plan. It is not a requirement here in the Philippines with regard to the checking the risk of the impacts, particularly in the environmental risk assessment. But in one of our projects, what we did was among the projects that among the environmental impacts that we have identified, we tried to identify which among these impacts will be more risky throughout the development phases. And I think that one planning exercise is very important, because what we usually do in the environmental management plan is everything is similar in terms of the degree of the impact, but we should also look into which among those impacts are probably more risky among others. Unfortunately, this is not yet a requirement in our planning system, but more on the environmental risk assessment in terms of the potential failure of the project. That's all.
Okay, Matthew, it looks like the third hand that was raised has been taken down. So would you like to comment on those two examples?
I think not just in terms of commenting on the examples, it's just that I think this is also where we see the link, and I also see there was a question from and point raised by Zinren in the chat about sort of risk and impact consequence. What I also think is very important is where we see this circularity of going from assessment and to your approval documents, and then reporting, and then you need from that reporting, and often we see that even if a company might report to the regulatory authority and we don't see any action. And that could be as a consequence of lack of capacity in the regulatory authority, or the regulatory authority has other issues that it's trying to deal with, which then gets back to the idea of how do you then have an effective implementation of your system, which is why I'm this strong advocate of using both technology but also community engagement, because I think we are putting too much on the regulatory authority that often, lacks, whether they lack commitment or capacity, they are possibly overwhelmed by the range of issues that they may face. And that's one of the reasons why I think trying to highlight the importance of community engagement and engagement at a project level might also be able to resolve some of the impacts that might be felt, standard and normal impacts, because as we know, in any EIA there will always be residual, or for any project development there will always be residual impacts. You're never going to avoid all impacts, whether it's traffic movement or air pollution or dust. But what we can try and do is then mitigate the practical consequences of those actions on surrounding residents, and often we do that through noise attenuation, or changes to hours of operation, or changes to ways that trucks move through communities. And they're all those practical things that can be perhaps resolved through that dialogue and negotiation at local levels. So I mean, I'm just sort of wanting to reiterate that consequence, or that need to ensure that the purpose of all of this is actually to try and avoid, the impact from occurring, and if it does occur, how to minimize the consequences of that from occurring.
Mm-hmm. Yeah, it looks like we have a follow-up comment from Shinren. Shinren, would you like to make your comment?
Yes, thank you. I just want to comment that the EIA is supposed to assess impact before any avoidance or mitigation or whatever, before any measure. So it's like objectively to assess, given this activity, that in the project design or in the project proposal, that surely will have certain consequences on environment. So need to assess that. And then if the consequences are formidable to the level that this project should be dropped, and then so that you inform the decision maker not to go ahead with this project. But in most of the cases, the consequences can be avoided by modifying or optimizing the project design, say changing the alignment or reduce the scale of that activity. And then you can avoid and reduce a lot. And as Matthew said, there's always something some residual impact, the consequences that will happen for sure with this activity. And then for that residual impact, and then you devise an EMP. So that's mitigation measure. And then probably further even compensation. So I think that should be a cascading hierarchy that should be reflected in the EIA. So first of all is indeed that, as Matthew said, informed decision making. And also I think we really need to distinguish from risk. Risk is something, the consequences that have a probability. So you can't say the impact that is riskier. You can say that impact are more significant, are more hard to bear for us, things like that. So otherwise, I think we got really confused. Thank you.
Thank you. I also think you make a really good point on the idea of when the EIA is being conducted, that there is actually a sort of an obligation on the EIA consultants or whoever's doing that to identify that if a project is going to have a too negative impact, that maybe that's a point where someone should say, look, this project really shouldn't go ahead because there's going to be too many significant consequences. And it could be a project that either is going to cause consequences because it has the capacity to produce certain chemicals or industrial processes that are very dangerous to the environment, and they don't have. But also it might be in the case of a development in the coastal zone or a development in an area that is likely to be flooded, for example, that the consequences of actions on that project are going to make that project untenable, or a stranded asset, or a road, for example, that's going to get flooded and washed away because it's not resilient enough to climate change. And so I do think that's also something, and perhaps that is very important as a fundamental part of EIA, that we now have to start to think about, for some of these projects, should they actually be built? Or how they could be modified to fit within parameters. I'm also intrigued whether anyone has actually, recommended to their clients that a project, especially a major project, shouldn't be built because it's going to have too many adverse impacts.
Yeah, may I follow up on that? And actually giving you a good example, as you asked earlier, like good practice. It happened that the EIA really veto a project, typically hydropower, with such a dire consequence, both environment and social. And it happened in China. So the ministry really use EIA basically veto it. And of course, there's backed up by a huge public protest outcry, let's say, against, say, certain hydropower. So it's not just Ministry of Environment. So, but that kind of cases is rare. I guess also for, say, World Bank and the ADB. That's what I say. Most of cases is still modified and then go ahead, something, yeah. But it does happen. And I think in our safeguard policy, we should make that as, you know, as a possibility, because that is EIA ought to be, as you said, yeah, it's supposed to be. It's not green branding or green washing to prove a project. Thank you.
Okay. Thank you, Sinren. We've got two earlier questions from the chat. One of them deals specifically with your risk assessment matrix. So, and we have another one on climate change. So let me ask the one, Heidi, would you like to make your comment, ask your question about the risk assessment matrix? Is Heidi still with us? Now, what she was asking, Matthew, is that, or what she was saying is there's a third dimension to risk assessment. Is that Heidi? Are you there?
Yes, thank you.
Okay, go ahead.
Yeah. I actually was thinking that the matrix should actually, this could be a third dimension, right? Because you have to look at your implementer's capacity as well. If the implementer doesn't have the strong capacity, then the risk is there, even if the likelihood of the environmental risk is not that great, right? If you don't have a good implementer and then inexperience, then that could also add to the risk, right? So I was thinking of in terms of disaster, because in some countries, they don't have a lot of disaster prone weather, but because they have very weak capacity, any little thing that hit them would incapacitate the government. So yeah, thanks.
Yes, I mean, I also think we, you know, this is the challenge with some of these major projects, is we're also learning a lot more. I mean, I've been doing this for 30 years, and in Australia, environmental impact assessment was never really as so detailed as it then has become in, and now in some ways they're looking at new mechanisms to try and deal with some of the consequences of major project planning. But that interesting thing is also about the systems, the capacity of the systems, whether it's the project itself and the operators to manage the complexities of the environmental management plan, or even the regulators. And I think that is, you know, I mean, that is something that we've seen now, that the capacity to regulate some of these major infrastructure projects is well beyond the capacity of national governments, because the project proponents are, you know, bringing the experts in from around the world. I think you've probably seen this too, Patty, that, you know, the project proponents are, you know, more international in some respects, and governments, it's just difficult to get that expertise to be developed. You know, some countries such as Indonesia and Thailand and others then also relied on academics to sit on sort of review boards. Again, that then creates issues of how independent are those reviewers of projects if they then are also working as EIA consultants in other projects.
Yeah. Now, Matthew, you in your comment, you also gave an example of climate impacts, you know, resulting either because of a project or because of unintended impacts. And Peter King has a question related to that. Peter, would you like to ask your question?
Yeah, thanks, Patty. One of the things I've been asked to do recently is to look at how ADB is addressing climate change in its project approval process. And one of the sort of strange arrangements is that while the impacts of the project on climate change is meant to be covered under the environmental impact assessment procedures. The risk and the climate risk and vulnerability assessment is a separate process and has a separate document from the EIA. What I was told is when that sort of division was agreed some years ago, it was because the impacts of climate change on the project was not seen as a compliance issue. Can you explain why there would be that separation in approaches between the impacts of a project on climate change and the impacts of climate change on a project?
Let's see. Well, Matthew, do you feel like you want to answer for ADB?
No, I was going to declare. First of all, I was going to say hello to Dr. Peter King, and also because as the coordinator of the Asian environmental compliance enforcement networks that have done, again, an enormously valuable job over the last, I think, is it 15 years of bringing together regulating authorities, and a lot of the experiences that I did learn, including in Singapore, where they use technology significantly to ensure compliance. They were at some good ASIN conferences, which also talks about bringing, developing capacity between countries within the Asian region. So big shout out to Peter and Chocho. I think you've just joined, and the work that ASIN is doing. But yes, Patty, I will say that I can't really comment on how ADB deals with that. Maybe someone else on the chat may.
Yeah, actually, I was just checking to see, because we did have two people from ADB, Environmental Safeguards, who were here at the beginning, and I don't see them now. Is there anybody from ADB who would like to address Peter's question? If not, Peter, you had a second. You had a second comment, just a question about, does anybody know of a project that has actually been not approved by the authorities?
The reason for asking that, Patty, is that increasingly what we're seeing in the region is that environmental impact assessments have become a tick the box exercise. I've seen EIAs recently that have been just cut and paste from other EIAs. Nobody is really checking. One very egregious example I saw recently was an EIA for a roads project that kept referring to hydropower because it obviously had been cut and paste from a hydropower EIA. My question really was, is EIA sufficiently powerful to actually stop a project from going ahead? Because I haven't seen any examples of that. And in my 15 years in the Asian Development Bank, I never saw too many examples either.
Matthew, do you want to ask? Okay. Yeah.
So I was just, I think, that's a really quite a powerful comment because we do rely on EIA a lot. And I think, there's also that idea about for some of these mega infrastructure projects. I'm thinking about rail lines in Malaysia or Thailand, or the Eastern Economic Corridor in Thailand, or a number of very large infrastructure works, port facilities, massive housing developments on the coast of Cambodia. Is EIA really the appropriate tool for some of these very, very, the mega projects? For a number of other projects, the level of assessment can be done. People can sort of comprehend it, but how can you comprehend a 300-page document, often technical? In some ways, I would say, well, we still use the system because, as Semin Yang has said, it is something that is adopted in all jurisdictions, but we still perhaps have to make look at it clearer and and revise it and focus on those things about improving both projects, but also identifying, especially through sort of early identification of risk and maybe that strategic environmental assessment in a broader scale. But it's also something that I see develop that project finances are doing, where banks and other lending institutions and insurance companies are being brought at the very early stages of project feasibility, and they're conducting climate change risk assessment, biodiversity risk assessment, land tenure resettlement risk assessment, because they know even at that early conceptual stage, those are key risks that can't be effectively managed, if you're going ahead with a project. And that, maybe gets back to the comment that's been made to me about, location being important. And in that way, for example, one project that I'm aware of is the IFC's hydropower strategic environmental assessment in Myanmar. And they recommended a series of recommendations, but one of them was that there should be no main stem hydropower on the main rivers and that would protect, just that decision alone would protect, close to 40 to 50% of the watershed. In other areas, there was a green zone and an orange zone, that there were, still requirements for environmental impact assessment. But it also identified that certain projects, hydropower projects, shouldn't occur because of the environmental and social risks associated with those projects at the main stem. And so that was quite a powerful decision-making tool if it was adopted. And I think that's where also potentially we can use new tools. I mean, in terms of climate change, I still think, if someone's putting in a greenhouse gas producing energy project, once they do a climate change risk assessment, it should be quite clear that we can't make any further contributions to carbon emissions. That will, of course, have massive other consequences. But then that also opens up the opportunities for further decision making as to where things go. Maybe that also does require strategic assessment for energy policy and the like.
I see that Shinren has raised her hand. Shin, I'm sorry, I didn't realize that you were with ADB Safeguards. Please, do you have a response to Peter on that? Everybody else who's raised a question, I'll get back to you, I promise.
Yes, I will try. And I think he asked, he hasn't seen after 15 years, ADB ever veto a project by EIA. Yeah, actually, I was asked the same question by project leaders, although I'm just a few years in ADB. But let me say that EIA is a tool to aid decision-making, not to replace. When you make a decision, you always weigh between different aspects of cost and benefit, right? If you consider that developmental benefit outweigh environmental consequences, as it turned out to be for ADB, certainly go ahead with all the project. And another layer is like for our project, we always have a preliminary judgment to categorize. So that veto kind of thing can only happen in the category A, say the project that it judged to likely have higher significant impact. But this kind of thing actually happened to World Bank, like for garbage incineration plant or some water resource management. And then but always a combination of environmental consequences and the social. So, and then sometimes halfway of the EIA, even without completing, and then it becomes so obvious that it's it's rare because it's only one aspect to feed into decision making. And also you asked about climate change assessment. why should be in the EIA. Actually, I agree with you because the environmental experts already overstretched. Environmental safeguards are overly multidisciplinary. We cover so many things, so it is humanly impossible. So I would rather to have some experts with climate change experience, knowledge on, say, adaptation, variability of future, change in different pattern, and then to really do a more professional job. And that is happening already in many projects. We have like a special consultant expert on climate change just to assess the climate risk of a project, in addition to the environmental expert who is focusing on environment consequences, which already include health and safety and many other things. So thank you.
Okay, thank you, Shinman. Itiha, I see that your hand is raised, but we have some people who've made comments who have not yet had a chance to speak. So I'd like to get to them first, but I know your hand is raised. I think, Kritika, are you able to ask your question, or are you still having difficulty? Let me just say, we have a question from Kritika. It says that monitoring reports should be published and reviewed by the public. In cases when the owner of a project does not want to and uses commercial secrets as the reason for doing it, what is your recommendation, and how should this be dealt with?
Yes, I mean, that's a very good question, and I think there's also sort of a related question, Patty, about public participation. What happens when it's not well liked by governments or the community? Yes. And I think yes, Bhagya Wickramasinghe. I mean, I think this is where it comes back to the idea that a central component or a central principle of environmental impact assessment is public participation and engagement. And so it can be argued that without that engagement and the ongoing engagement of the community, it's not a genuine EIA. And that, maybe that's a decision governments want to take. In terms of companies claiming commercial in secret, this was an argument that was used by the fracking industry. They didn't want to disclose all of the chemicals that they were pouring into the underground because it was commercial in confidence. And we've seen that the consequences of that is widespread environmental pollution. So my view is always there might be a particular element that really is commercial in confidence. But in terms of reporting whether you are in compliance, if you are putting chemicals or using chemicals, you should have a condition that relates to that. And then you should be able to show whether or not you are complying with that, especially if it's a dangerous or a toxic substance. The same with waste management. Too often we have conditions that say, you may have to use a licensed waste disposer to remove your waste. Well, that waste disposer, the license of the waste disposer should be a public document so that the public can also check to make sure that the waste disposer is genuine and is in fact licensed, rather than the company saying, oh, well, they had a license, we think it's valid, we didn't check. And that's where I think, in terms of coming back to this idea of commercial in confidence, companies are wanting to make profits by doing activities that have consequences and impacts. And there has to be a recognition from the companies that in order to do this and make their profits, they have to accept public view as well as the regulatory view. And that's one way of potentially strengthening EIA. Otherwise, it will get more and more, people won't trust the process. And that can only lead to further conflict and further delays in the system, which I don't think is which is not in the interest of anyone, because what often happens then is governments decide to approve projects without EIAs or without any form of assessment, in which case it excludes the community and often excludes the environment, and with often very, very significant and negative consequences.
Thank you, Matthew. We have another question from, I hope I'm pronouncing the name right, Toldina. You have two related questions for Matthew. Would you like to ask those now? If you're not here. Okay. I'm going to go on. Let's see, because we have so many questions here. There are, let's see. Okay, here's another question. Well, another question from Toldina, who seems not to be here. Okay.
Toldina is here.
You are? Okay.
Yeah.
Would you like to ask your questions then?
Okay,
Okay.
Thank you. Yeah.
Sure.
I actually think that when I wrote the question and Matthew will respond. Anyway, yeah, I can repeat the question. My name is Toldina. I'm the government officer of the Ministry of Land in Cambodia. And also I'm the technical director of the land allocation for social and economic development in Cambodia. I have three questions. So the first question related to indigenous community, that when we do the land titling project, the donor, especially like World Bank or ADB, they require us to do the ESIA. And in such a case, I just want to hear from Matthew, who is quite very experienced with the ESIA. Are there any such like ESIA on indigenous land titling in Southeast Asia that we could learn from other countries besides Cambodia? The second question is about the conduct of ESIA. I'm wondering whether the executive agency can conduct the ESIA by themselves for the project that funded by international organization. And my third question is, I want to learn any good example that the government project fully apply with the ESIA in their project, because to my observation, I found that it is very, very hard to consider many of the points raised in the ESIA report, and then try to the project implementer try to comply with those requirements, because like the project has a limited period of time, and if we try to comply with those suggestions or recommendations, it take very, very long time. Sometimes we spend almost the whole 2 or 3 years just in order to comply or to answer all those recommendation and suggestion. So in this case, can the implementer or executive agency sometimes try to avoid some of the suggestion or requirement on this ESIA? Thank you.
Thank you. All very good questions. So just on the specific one, I'm personally not aware of an environmental social impact assessment procedure for the granting of land tenure to Indigenous groups. I'm personally not aware, but that's probably because I don't do a lot of work on land tenure issues, in terms of the granting for, maybe someone in the Philippines may be aware, because the Philippines do have a very sophisticated system of not only tenure but recognising free prior informed consent for Indigenous communities. So I'm not aware of that process. I know in Australia, for claims to grant land to Indigenous communities, it's done in a particular type of mediation process, but I'm not aware of any environmental impact or social impact that is done on whether it's going to benefit the community. I think that's always a given. So, and in terms of the conduct of ESIA, my view is always, and again, because I believe quite strongly in transparency of process, that it's often better for an executive agency not to conduct its own assessment. It can hire an independent EIA consultant, and they should be open and transparent, because the executive agency, and I know this differs in different countries, the executive agency, obviously it's in its interest. It may be proposing a project. So, and the idea of the EIA is that it's meant to be a decision-making tool that should have some sort of independence from the people who are making the decision. And then I think in terms of that final observation, because EIA is a process, if you comply with the most important points of it, and identify the issues and identify the most significant issues and try and mitigate them and develop plans to mitigate them, that substantial compliance is probably the best we see in EIA. And I think as a consequence of what we often see is a lot of time being taken up in smaller, less significant issues, and that can divert attention away from some of the most significant issues, which then gets back to the idea of, this comment that was made to me that once you've chosen the location of a project, really 70% of your issues and your problems are going to be locked in. So, but it's always difficult because EIA is a project-based. Often, a project proponent will have its area of land, and it wants to build a factory, a chemical factory, or a particular type of project. It's not open to different areas of land or different projects. That's what it's going to build, and that then means that a lot of the impacts are already going to be clearly identified. It still means they have to be mitigated, and I think also one of our problems is that in some ways we sometimes lose perspective that the real value of an EIA is to aid decision making, but it's also to ensure that if the conditions are complied with, then the residual impacts are going to be acceptable to the community because of the benefits that project brings to either that community or society. So it is a balancing situation. Again, what we face now is significant challenges to biodiversity. The Secretary General, in releasing a report, said, we are waging a war against nature. And one of the consequences I think we have to consider is how can we pull back? But there is also the need to ensure that we still provide opportunities for employment and education and economic activity, but in a way that doesn't create the harms to the environment that we've unfortunately seen over the last number of years increasing.
Yeah. Okay, everyone, I'm very conscious that we're already past our time limit here. We've got about 4 more questions or comments and 1 more hand raised. Matthew, are you happy to go ahead and deal with these last questions, or
Sure.
Anybody who would like to stay on, please do. We're really happy that you're staying on. There's a question, and in the interest of time, I'm just going to let Matthew know what the questions are. There's a question about the role of environmental mediation committees in enforcement in the EIA process. Would you like to address that?
Thank you. And I can also address the question on the violation of the courts. So
yeah,
so
okay.
I think
I was going to let you do that separately.
Thanks. Well, one of the things that I think we found that has been raised as an issue is that there are often disputes that are project-related disputes that could be managed or addressed by being able to deal with those things at a local project-based level. Not all, but some. And the idea of a mediation committee, which came up in Cambodia when we were drafting the Environmental and Natural Resources Code, is the idea of creating, community mediation committees as part of that sort of either broader, as part of a system of environmental dispute resolution, or within sort of project-based areas, mining. And that mediation committee could try and resolve those disputes before it gets to the point where the regulator has to step in with orders, or the prosecuting agencies have to step in with prosecutions, because they all cost more money, and ultimately they can take a long time before some impact can occur. One famous case in Thailand is the Clitty Creek litigation, where a number of people, it wasn't necessarily related to EIA, it was a pollution incident, and a number of people sued the company for damages. It took 10 to 15 years. Some people died before that. The creek itself, the remediation efforts took a long time before the court ordered remediation. There may have been opportunities for some of those issues, especially the remediation, to have been dealt with much quicker. And that's the idea that has been raised, is that for these projects and the impacts that they cause, construction as well as operation, if we can look at resolving them as quickly as possibly in a local way, but if they can't, then we might need formal courts. In my view, because of the technical issues about environmental and social impacts, and I am a strong advocate for environmental courts. I mean, that's also something that the ADB, we have a judicial program that trains judges to provide capacity building for judges on environmental issues. That also has led within many countries in Asia to develop environmental courts or tribunals or chambers that are specialized to deal with environmental matters. And that can be quite successful as well, because they have that specialized knowledge.
Mm-hmm. Yeah. Yes, the issue of project-specific grievance redress mechanisms of any kind, not necessarily just mediation committees, is something that tends to come up with, particularly with social impact assessments, and maybe not quite as often with environmental impact assessments. We had another question that was looking at the extent of requirements for disclosure, and Matthew, I think you've already made the point that you are a firm believer in transparency and maximum disclosure. Is there anything else that you'd like to say on the issue of disclosing EIAs and the reports and things?
I just want to sort of point out, one example of disclosure is in China. Initially, China only disclosed summary reports, but after a consequence of litigation, they amended the China Environment Protection Law so that there are now full disclosure of EIA reports required under Chinese law, and that that's significant. I should also note that in China, when they amended the law, they also inserted a liability clause so that EIA consultants who are involved in projects can be held liable for errors within the EIA report. I'm not sure I'd go that far, but I do believe very much that one thing we could work on is providing a great deal more education and support and capacity development for EIA consultants, and also creating sort of an international good practice. Again, the EIA-NZ, the Environment Institute of Australia and New Zealand, does a lot of capacity building within Australia and New Zealand. The IAIA and certainly IAIA, who was here from the Myanmar Environment Assessment Association, which through the support of the IFC have done a lot of training, capacity development within those countries, we can keep doing that because the EIA consultants are a vital link in a better EIA system.
Okay, we have two questions actually from one of our participants. One is looking at costing environmental impacts and how to build that in to EIA, and along the same lines is looking at how to link EIA with the green economy. So we've got those two questions, and then I think, because we're already 10 minutes over time, I think we'll stop with this. But Matthew, go ahead and with those two questions on economic issues.
So in terms of the green economy, one of the things that, and again, this was a discussion, this EIA webinar, and I think we gave the link in the promo material. It had people from Australia and Asia and South America looking at sort of how best to include a number of issues within EIA. It's interesting, I think the Europeans are probably approaching this through the EU Green Deal. And the idea is that what they're trying to do with that Green Deal is ensure that pollution control, life cycle technology, extended producer responsibility are all included in decision making. Whether EIA is the right tool for that, and I think Siren did mention that we must always remember that EIA is one tool for decision making, and there should also be other government policies. But certainly within an EIA process, extended producer responsibility, life cycle assessment for particular projects could all be looked at within the EIA. It makes it more complex, and again, you need specialists, but that is potentially one to use it for, or it could be a standalone as a government policy. And finally, just in terms of costing, my view is that EIA consultants should always charge more. I
don't think that's what he meant.
Yeah, I know project proponents don't like that, but it's a time-consuming process, and I think sometimes it's very important to say to project proponents that the process is time-consuming. Public consultation does cost money, but this is all should be part of the cost of the project, and that means that the banks, the financial institutions, should all take this into account. And indeed, a number of the global financial reporting requirements and the Global Compact, for example, the global financial initiatives look at or require the Equator Principles, for example, all say that banks should require EIAs to be done. And that means that really the banks should also include in the cost of the project a good EIA conducted by an independent, impartial and transparent team with good qualifications, and that should be considered as part of the project costs. In every circumstance where I've seen projects come unstuck because of EIA, it's because the project proponent has not invested in a good EIA or a good process. And that, to me, shows how important the EIA process is to approvals, but it also is a good EIA means that the ongoing nature of the project, the operations can be far less trouble because they're done in a way that minimizes environmental and social impact. I do know that that this is an ongoing issue, and the IAIA, and I'm happy to share with the ADB team and the work that Cheryl Wasserman and her committee have been doing, and it's an ongoing process. I mean, I think that's also something that we recognise, having worked in this area for perhaps longer than we care to admit. Isn't that right, Patty? So.
Okay. Okay, Matthew, on that note, longer than we care to. I'd like to thank you, Matthew, for everything that you've put together for us today, for a really comprehensive presentation that also drew out, you know, a really fascinating range of comments and questions from all of the participants. And also to all of you, you know, who are still with us, many thanks for having been here, for having contributed. We really appreciate this, and we look forward to seeing you in the subsequent webinars that will also be part of this. And for that, Christina, I will hand that over to you to give your thanks on behalf of ADB and let everybody know what the upcoming events will be. Do we have Christina? Okay.
Hi, sorry.
Okay. Oh, there you are. Oh, hi. Sorry. Okay. Okay.
We are still deciding on our, sorry, my camera's off. Yeah. Thank you very much for staying. Matthew always keeps people almost 30 to 40 minutes after. We always have such lively discussions. In fact, this second EIA webinar was because the first one didn't want to end. And we were like, Matthew, we need a part 2. So it looks like we need a part 3. We're still in flux about what the best, that's how organic we are, Patty. Now we do have a few coming up. We will post on our website, and we just, I don't know, for the people left behind, we have just a little video on what our program does on professors, you know, training professors to improve the teaching of environment and climate law. But Matthew, maybe you should give the last word because we have so many still open questions. So I think you should do the last.
I think it would be great to roll the video. And thank you all very much for participating and the questions. And I've just asked Angelo if we can capture the questions and reformulate this into a little bit of a discussion paper, which hopefully will also you know, influence the work of ADB and their safeguards team, but also the other you know, funders within the region and other institutions, because of that need for strengthening what is obviously a very widespread and important decision-making tool. Thanks.
And remember, the recording of this is going to be on teachenvirolaw.asia. So if you missed anything or you want to rewind and you know, remember what Matthew said, at some point this will be available. So thank you very much. And Matthew, we already have a request for part 3.
Thank you again, everyone.